All right, Aiden Lujan Bakon, come.
Right here.
come up. Hello, how old are you? 18. All right, so here's my question. Are you on all of the cases?
Yes, sir.
All right, so where are we on discovery?
We are okay on the drug case, Judge, but my client picked up a new case February the 1st.
Right, and are you on those two new cases?
Right.
All right, so state, I'm gonna recall this for 45 days. And if you'll make sure that he has the discovery on the other cases. All right, Ms. Ferguson, I need a 45-day reset. Are you in school?
Yes, sir.
April 30th. April 30th, is that school day for you?
It's a Thursday.
Well, I'm trying to figure out what kind of breaks they have. Now they're doing all this newfangled thing where,
I'm in a GED program. So.
all right, so can you look at your calendar? I don't want you missing your program.
No, it's fine.
No, we're not doing it's fine with your missing your school.
April 30, it's because my school's from like 5 to 9.
5 to when?
5 to 9.
Ah, so you'll be fine.
Yes, ma'am.
Okay. All right.
The afternoon? Yes.
See the new things they're doing?
That's a surprise to me.
Okay. So we're going to bring you back on April 30th, and it's for your attorney to get the discovery on the other cases. All right. Once you sign the reset form, you are excused.
Thank you.
All right. You're welcome.
Yes.
Yes.
I don't know if it's appropriate, but I'm a fan of you. I always see you on TikTok.
Hi. Hey, well, this is what I want you to do for me.
This is a bad way I had to meet people.
Oh, okay. Well, here's what I want you to do for me, okay? You are very young. To stay out of trouble for you, if there's any trouble, you got to stay in the house. You know, you should either just be studying for your exam or in the house or at work.
Yes.
I'm sure your attorney will tell you that. So just make sure you do that, okay?
Okay, thank you.
All right, good luck to you. Court is calling 2025 CR 0125772-02, State versus Carl Robinson. Can I have parties announced?
Michael DeLeon for Mr. Robinson.
And are you Mr. Robinson? Counsel, you received all discovery. Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Robinson, did you review the application for deferred adjudication with your attorney? Did you understand it inside it?
Extensively, yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Judge will be waiving all but count 1, but also be proceeding only on the lesser included charge of robbery.
Any objection?
No objection.
All right. Did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right. You're charged with robbery. That's second-degree felony. Range punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Oh, off the record. Bye, Rick.
Hi, Judge.
All right.
Thank
you,
everybody.
All righty. Leave men behind.
Just random.
Okay. Oh, wow. All right. We're back on the record. Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of offense?
I do believe he's currently competent.
All right, Mr. Robinson, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No coercion is present.
Anyone promise you anything other than the plea?
No,
Satisfied with the way you've been represented?
certain.
If you're not a U.S. citizen, by entering this plea, you will be deported and denied naturalization and reentry. Did you understand?
Thus I comprehend.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand?
Yes, ma'am.
According to the plea, state is proceeding on count one, the lesser included offense of robbery. They're asking that your punishment be assessed at a cap of 6 years in the prison. They're opposed to your applications. Did you understand that to be the plea?
I do understand.
Defense?
That's correct, Your Honor.
State?
It is correct, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No motions, Your Honor.
Then to count one, the lesser included offense of robbery, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Judge, we offer to exhibit number one, including all of its evidence.
We reviewed that, Your Honor. No objection.
I state you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Extensively, yes, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
I do comprehend.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. All right, counsel will come back for sentencing. And on your client, does he need a TAP evaluation?
I don't think he needs one, Judge, but it's easy to do one if the court wishes.
All right, any MIC evaluation?
No.
All right, this will be a TAP and PSI, and we'll come back on the 13th, the 30th.
27th,
Sorry.
April 27th.
We need a date right now.
All right, so we'll be back on April 27th.
Sounds good, Judge.
All right, see you then.
All right,
Thank you.
Yes, ma'am.
Yes.
As the court knows, I just got a point on this afternoon. I've gone through the files, had a good conversation with Mr. Cruz. I think we've got some issues that we can defend. I really want to pull discovery and kind of compare what I know from the report and what he's telling me we're going to see. So I just probably need a regular reset just so I can get some time to get the discovery and do what I need to do on my end.
All right, Ms. Ferguson, set this for a plea deadline date in 30 days. And the reason why I'm doing that, counsel, it was previously set for a plea deadline date.
Give you April 16th.
April 16th.
April 16th, perfect, Judge.
Okay.
And Judge, I'm going to file a motion for a bond reduction.
Okay.
Just get with Ms. Ferguson and
Yes.
get that set.
Yes, and they'll probably set it. Well, it depends on whoever set the last bond. Norman, can you look in the system and see if a magistrate judge set the last bond or if a district court judge set it? That's okay. Obviously it's moving slow. I'm going through that as well. But I will tell you this, if a associate judge or magistrate judge set it, then it can go to
Nahara?
Nahara or Hallstatt. But if a district court judge set that, only a district court judge can give a reduction.
Makes sense. Are these the original bonds? The amounts that were bonded? Yes, sir. From where you get mag, right? You probably do it through a mag judge, I bet you.
All right, so
But
if he-
I'll double check it.
Yes, if he did it through a magistrate judge, then so that it can be expedited, we can have it sent to Judge Nahara or Judge Hallstatt.
Perfect, Judge. Thank you.
Okay.
I'll get that draft and we'll get it one
All
back.
right, thank you.
All right. Thank you.
Thank you.
Thank you, Your Honor.
You're welcome.
What happened in that courtroom today was a reminder that the justice system doesn't move in a straight line. It moves case by case, person by person, decision by decision. 18-year-old Aiden Lujan stood before the judge with open cases still being sorted, discovery still pending. But instead of a lecture, he got something rarer in a courtroom: genuine concern. The judge didn't just reset his date. She told him, stay home, stay out of trouble, study for your exams. A young man still in school, still with a chance to pivot, and a judge who seemed to actually want him to take it. Then came Carl Robinson, facing robbery. a second-degree felony carrying up to 20 years in prison. His attorney had done the work. The plea was structured, the process was thorough, and Robinson himself answered every admonishment with clarity and composure. The court deferred its finding of guilt, granting Robinson an application for deferred adjudication. Now he heads into PSY and TAP evaluations, scheduled for April 27th. The door isn't closed, but it's conditional. Every step forward matters. And then there was Mr. Cruz, newly appointed counsel, bond reduction motion in the works, discovery not yet reviewed. His case is far from resolved, but the wheels are in motion. A reset, a plan, a fighting chance. 3 defendants, 3 different crossroads. One courtroom managing the weight of all of it, calmly, methodically, and with more humanity than most people expect to see behind that bench. That's what real justice looks like in practice. Not dramatic verdicts, but careful process, second chances, and accountability measured one hearing at a time. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns, because justice never gets old.